Welcome to the Deck Dive. Today, we're tackling a really significant piece of South African law. It's the Reform of Customary Law of Succession and Regulation of Related Matters Act, Act 11 of 2009. Quite a mouthful.
It is, but it's incredibly important. It essentially bridges constitutional principles with, well, long-standing cultural traditions.
Exactly. And if you've ever wondered how law handles that kind of complexity, modern equality versus diverse family structures under customary law, this deep dive is definitely for you. Our aim today is to really unpack this act. What's its purpose? What are the key changes it brought in? And, what's its real-world impact been?
Well, it's a cornerstone reform, no doubt. Assented back in April 2009, commenced September 2010. Its whole purpose was modernizing succession for people living under customary law. And it's still very relevant. There was actually a very recent update noted October 2024, and some administrative functions just shifted to the Minister of Justice this year, June 2024, so it's actively maintained.
Okay, let's rewind a bit then. Before this act, what exactly was the problem? What needed fixing so urgently that Parliament had to step in?
The context is crucial. You find it right in the Act's preamble. It lays out the why. There were fundamentally three big issues. First, under the old rules, widows and certain children just didn't get fair treatment when it came to inheritance. They often lacked protection.
Okay.
Second, society had changed. The social structures that maybe supported the old customary law weren't really there in the same way. The law wasn't adequately providing for family welfare anymore.
And the constitutional angle.
That was the hammer, really.
Yeah.
Section 9 of the Constitution. Everyone has the right to equal protection and benefit of the law. That was the non-negotiable standard.
Right, and that led to a major court decision, didn't it? The Constitutional Court weighed in quite heavily.
It did. It basically looked at the principle of male primogeniture, where only the eldest male heir inherits everything, and said, nope. The court declared it incompatible with the Bill of Rights. Equality, human dignity, primogeniture just didn't square with those modern values. That wasn't just a suggestion. It was a clear mandate for Parliament to act.
A directive, essentially. Fix this.
Precisely. So the Act's purpose became clear. Modify customary law, get rid of that male primogeniture rule for inheritance, and make sure property devolved according to the standard law of intestate succession with necessary adjustments.
Okay, so let's dive into those adjustments. Section 2 seems pivotal here. It changes the whole game for how estates are handled when there's no will.
That's the core mechanism, yes.
Yeah.
Section 2.1 lays it out. If someone subject to customary law dies intestate without a valid will after the Act started, their estate, or the relevant part of it, now follows the rules of the Intestate Succession Act, 1987. That's the standard framework now. The old customary rules for succession, gone.
But the Intestate Succession Act, the ISA, was largely designed with, let's say, civil marriages in mind, often monogamous ones. How does this reform protect spouses in customary marriages, especially where there might be more than one spouse?
Good question. The Act anticipates that. Section 2.2 provides specific protection. If the deceased leaves a spouse and descendants, that surviving spouse gets a guaranteed minimum. They inherit either a child's portion of the estate or a specific monetary amount set by the minister, whichever amount is greater. It ensures the spouse isn't left with, well, potentially very little.
And crucially, the definition of spouse here is broad, right? It explicitly includes partners in customary marriages recognized under the Recognition of Customary Marriages Act.
Exactly. It covers customary marriages properly, including potentially polygynous ones. That recognition is key.
Okay, now things get a bit more complex, reflecting the reality of customary family structures. The Act has to expand definitions beyond what the standard ISA uses, particularly for descendant.
Yes, the standard definition just wouldn't work. Customary law often has broader concepts of family and lineage. Section 1 and Section 2 bring these in. So descendant under this Act isn't just about biological or adopted children as per the ISA. It expands significantly.
Let's talk about the concept of the house here. It seems really central to understanding this.
It is. The house is a fundamental unit in many customary systems. Think of it as a distinct family and property unit, usually established by a wife within a larger family structure. This Act acknowledges that. So descendant now includes, for example, someone the deceased accepted as their own child according to customary law, even if they don't fit the standard ISA definition. And it goes further. It recognizes unions specifically created to provide children for a particular house. This could be a woman, other than a spouse, who entered a union with the deceased for that purpose. She might be considered part of that lineage for inheritance. And conversely, if the deceased was a woman who married another woman under customary law, a practice sometimes used to raise heirs for the first woman's house, That second woman can also be considered a descendant for inheritance calculation purposes.
Wow. That's a significant legal recognition of relationships and structures often overlooked by standard civil law. But practically speaking, calculating inheritance shares must get complicated. How do you figure out the child's portion with multiple spouses, different houses, these expanded descendant
It
categories?
is complex, but Section 3.3 gives a formula. It's quite specific. You take the total monetary value of the estate, and you divide it by a number. That number is calculated by adding up all the children and descendants who qualify. PLUS, the total number of surviving spouses, A and D. Those women we just mentioned, the ones recognized in Section 2, related to providing children for a house.
So everyone who represents a kind of family unit or lineage branch gets counted in that divisor.
Essentially, yes. It aims for a form of equity across all the recognized family units connected to the deceased.
What if the estate is very small, too small to give even that minimum monetary amount you mentioned earlier to each spouse or qualifying woman?
Section 3.2 covers that. If there isn't enough to meet that minimum threshold for each of them, the Act says the estate is simply divided equally among those specific surviving spouses and women. It prioritizes them in that scenario.
Okay, that makes sense. Now, shifting from who inherits to who controls property, Section 4 seems to empower women regarding property allocated to them or their house. How does it clarify their ability to make a will?
It's a major step for property rights. Section 4 states clearly that any property allotted or accruing to a woman, or specifically to her house under customary law, can now be disposed of by her will. She has full testamentary freedom over that property.
That sounds like a significant departure from some older customary practices.
It absolutely is. And the Act adds another layer. If her will mentions her children or descendants, that reference must be interpreted to include any children born from those special unions created to provide children for her house. It ensures those children aren't accidentally excluded by vague wording.
Given all this complexity merging two legal systems, recognizing diverse family structures disputes must happen, what's the mechanism if there's confusion over who counts as an heir or what counts as family property?
The Act foresees this. Section 5 sets up a dispute resolution process. If there's uncertainty or disagreement, maybe about someone's status, or the nature of an asset, or how family property should devolve, the Master of the High Court has the power to investigate and make a determination that is just and equitable.
Could you briefly explain the master's role for listeners maybe not familiar with the legal system?
Sure. The Master of the High Court is essentially the chief state official overseeing the administration of deceased estates, trusts, and insolvencies. They're the key supervisor ensuring things are done correctly. And importantly, in these customary law disputes, the master can decide how to investigate. They might direct that a formal inquiry be held, and that inquiry could be conducted either by a magistrate, a judicial officer, or by a traditional leader.
Interesting. So traditional authority still has a potential role in resolving these issues.
Yes, but with a crucial guiding principle, whether it's the master making the final call or a magistrate or traditional leader making a recommendation after an inquiry. The decision must always consider the best interests of the deceased's family members and, critically, the principle of equality of spouses in customary and civil marriages. That constitutional imperative overrides everything.
But the Act doesn't completely sideline traditional leaders, does it? Section 6 seems to preserve their role concerning communal property.
That's an important distinction, yes. Section 6 clarifies that this act doesn't change the customary law rules about property held by a traditional leader in their official role, on behalf of the whole community. That property isn't part of the leader's personal estate. So the act rightly keeps personal succession separate from the administration of communal assets.
Okay. Connecting this back to the bigger legal landscape, the real significance often lies in how a new law interacts with existing ones. This act amended some major pieces of legislation, didn't it? The schedule details those changes.
It did, and that shows how fundamental the reform was. It had ripple effects. For example, the Administration of Estates Act, 1965. That act used to explicitly exclude estates governed by customary law from certain provisions. This reform removed that exclusion. It brought customary estates fully into the fold of standard estate administration. It also had to be updated to acknowledge that under customary law, there might be more than one surviving spouse who needs to be notified about the death in the estate process.
Makes sense. And the Intestate Succession Act itself, the very act this reform relies on, needed changes too.
Yes, logically it had to align. The ISA was amended to incorporate this act's broader definition of descendant, including that child accepted under customary law, for instance. And significantly, it was amended to remove outdated, problematic references to the old Black Administration Act of 1927. That was a crucial step in cleaning up discriminatory remnants from the statute books in this area.
There was also an amendment relating to maintenance for surviving spouses, specifically looking back historically.
That's right. The Maintenance of Surviving Spouses Act 1990 was adjusted. Its definition of survivor was broadened. It now includes a spouse from a customary marriage that was effectively dissolved because one party entered into a civil marriage during a specific historical period, basically between 1929 and late 1988. This addresses a historical anomaly where a customary spouse could lose rights due to the subsequent civil marriage under the old regime.
And Section 7 of this Reform Act reinforces that historical protection, doesn't it? It clarifies the property rights situation for those specific overlapping marriages from that 1929 to 1988 period.
Exactly. Section 7 states very clearly that if a man in a customary marriage entered into a civil marriage with another woman during that specific time frame, that civil marriage doesn't diminish the property rights of the original customary law wife or her children, and the widow from the civil marriage doesn't gain superior rights. Her inheritance position is treated as if her marriage had also been a customary one. It prevents the civil system from overriding prior customary rights during that specific historical context.
When you look at it all together, it really feels like this act performs a kind of legislative bridging act. It identified the constitutional problem, male primogeniture clashing with equality. It then abolished that rule for succession, but instead of just imposing the civil law wholesale, it carefully wove the Intestate Succession Act into the existing complex fabric of customary family life, making sure concepts like the house and multiple spouses were properly accounted for.
That synthesis is precisely its strength. It achieved constitutional compliance, which was non-negotiable, but it do so, arguably, while respecting the underlying social structures of customary law as much as possible. It undeniably shifted power towards women and children who were previously disadvantaged, aligning succession with equality while still acknowledging the unique ways families are structured and recognized under custom.
Which brings us to a final thought for you, the listener, to ponder. We heard that the master of the High Court, who must ensure equality, can actually refer disputes under this act to a traditional leader for an inquiry. Now, given that traditional leadership structures themselves have historically often been patriarchal, how effectively does this act manage that inherent tension in practice? How does the constitutional demand for absolute equality truly balance against the inclusion of traditional authority in resolving these deeply personal family disputes on the ground? That ongoing balance is perhaps something worth watching.